property rights. Now come to yes. See, the intellectual property is again divided into industrial property and the artistic work. Artistic work means whatever you are doing in music or whatever you are doing as a book write, it's all comes under attack. So now the technology, what you people belong to, what we people belong to a technological driven society where we basically do something called some engineering, basic engineering or medical or medicine or pharmaceutical science, where in day-to-day life we are working on some what you call some idea that is driven by our own mind. So these are comes under the intellectual property of industrial property. So these are again divided into three aspects. One is the patent, second what is the design, and third is the trademark. So what is a patent? So patent, suppose a student who is working on a laboratory, what he did, he just developed a technology related to an mobile phone, let's say a cell phone. So suppose he want to protect that kind of technology, then he have to get a patent on that particular technology. So that will cover the patent aspect. Suppose I am having a mobile and I am having a rectangular shape. Suppose Dr. Narendra Babu sir having a mobile, he is having a what you call square shape. So this kind of shape generally comes under the design aspect of intellectual property right. Now come to trademark. What is trademark? Suppose I am Subrat Sahu. I want to market my product under my own logo or under my own symbol. So what I will do, Subrat, I will make a R upper there registered mark. So that particular logo is basically specify my own identity. That even non other person can even take that particular identity. So that comes under trademark. Now other intellectual property also we are giving the right, that is a geographical indication, the layout design of integrated circuit or the trade secret. In the geographical indication we'll discuss some good example in one by one. So now come to the patent one. Yes, see, what is a patent? It's an patent, it's an intellectual property rights given by India through Indian Patent Act 1970 to the inventor who invented an invention. The invention may be a product or may be a process. So what is patent? Patent is an exclusive monopoly right. Basically, patent are the territorial right. It is only applicable to a particular territory. Suppose you are having a patent in India, then it is not applicable in USA. That is not applicable in the what you call the America in China. For suppose you want to get a patent of a same product, what you have obtained in India, you need to file the same process in different country because the different country have their different jurisdiction, they have their different statute that work for their own what you call own development, own generation. So you again have to file for the same patent to get granted in different way in different country. So it's an exclusive monopoly right which is given to a particular person who invented that particular technology. Now comes to industrial design. As I already discussed, it is for the external features which appealing to an eye. That is called the new shape or patent or ornamentation or any configuration. So these are all comes under the industrial design. Then trademark, as I also discussed about the per visual symbol as a word or as a name or as a logo or as a label or a combination of colors. So these are all comes under the trademark aspect of the intellectual property. Now comes to copyright. Suppose I am an author and I have written a book. Let's say I am written a book on the institution of patent and technology with comparison with the US. So I have written that one. I have used my manpower. I have used my intellectual power. I have written a book. If I will not cover, if I will not get protected under a specific intellectual property right, then somebody else he can stolen my book and he can sell to somebody else. So with respect to protected my own book, I will get through protected through copyright. So for any artistic work or any musical work, all these are covered under the copyright. Now comes to geographical indication. What is geographical indication? Suppose your, see, we are the large country, the vast country, we have different geographical location and we have the different significance of each geographical location. Let me take you one example of the Tirupati Laddu. See, the Tirupati Laddu, it is having a specific size and specific structure and specific quality. Nobody, nowhere in this world can produce this kind of laddu having same quality or same structure and same flavor. See, this kind of laddu, it particularly present to a specific part of our India that is belong to Tirupati. So we are giving a specific location, geographical location, specific quality to Tirupati through geographical indication. So it is protected through geographical indication so that nobody can make this laddu and sell as by saying Tirupati laddu. Only the Tirumala Tirupati Devasthanam can produce that kind of laddu and sell. This is the intellectual property right given to the Tirupati. Now come to another example, the Venkatagiri sari. I think most of you people heard about the Venkatagiri sari. Special the sari, the main quality of the sari is it is made up of the pure cotton and having the gold and the silver jari work. See, nowhere in the world or in the country is making this kind of sari with this kind of design. See, this is a special quality to a specific place of Nellore district. If I am not wrong, it is in Nellore district, the Venkatagiri sari. So our Indian government, what he is doing, it is providing a specific geographical location, specific geographical indication to Venkatagiri sari. So these are the all kind of intellectual property which has been protected, our own what is called our own intellectual mind or our any idea. So these are the basic intellectual property rights. What are they? The patent, the industrial design, the trademark, the copyright, the geographical indication, the trade secret, and the design and layout of any integrated circuit. Now come to different act. See, these are different act which generally protected our intellectual property right. As I have already discussed, Indian Patent Act 1970, which protect the patent, which generally related to the technology or innovation, the day-to-day life, what we are facing, the problem. Suppose some new technology or some new invention has come to in our life that will improve our life, then that is protected by the Indian Patent Act 1970. Similarly, the trademark is also protected by the Trademark Act 1999, and the copyright also protected by Copyright Act 1957. Now come to the Geographical Indication Registration Act. Geographical Indication of Good and Registration Act, it is comes under 1999. It also protected the particular geographical location, geographical goods or product. Similarly, the Design Act also specifically produced. It is specifically mentioned in the Design Act 2000, which generally protected the design. Similarly, another act we have also enacted in 2000, that is the Semiconductor Integrated Circuit Layout Design Act. Those people who are working on the electronics or engineering subject, suppose they have developed a semiconductor of a circuit, integrated circuit, they want to protect that one, then what they will do, they have to protect through the semiconductor integrated circuit. So now come to the next one, what is patentable? See, what is patentable? Any invention. What is an invention? Invention means any new process or new product. Any new process, just keep in mind, any new process or new product which is known as the invention. How it is patentable? See, a invention is patentable only if it is new Hello. Sir, I'm not audible. Okay, okay. Actually, it's not showing. My presentation is not showing here. But here I am not seeing my presentation. Sir. Okay, okay.
Sir, go to files, sir.
Okay.
And open that PPT, sir.
Yes, I have opened that one.
Okay. Now,
Is this visible now?
yes, sir. Visible.
Okay.
Sir. Close that yellow notification.
Yes,
And
I have already closed it.
okay, full screen and continue, sir.
Okay. Yes. So we have left somewhere in the Act, in the statute. So these are the Act which govern the intellectual property right, sovereignty within the territory of the India, within the jurisdiction of the India. So through this Act, we can protect our intellectual property rights. Now come to the patentable. See, what is patentable? Any process or product which is a new one is patentable. Then what is an invention? Invention means a new product or a new process which is having an inventive step and capable and which is can made in an industrial scale is known as invention, and these three qualities generally used to grant a patent. So suppose I am having a pencil, this pencil, see this pencil, this is totally new one. Suppose nobody has, so before me nobody has invented this kind of pencil. So this is the new one. So this is an invention. And what is an inventive step? Suppose I am having a pencil and I am having an eraser. So I am having an eraser there. So it is a dual purpose. So this is an inventive step. Inventive step means this is having a technical advance as compared to prior one. Suppose initially someone has a pencil. This is having only a single pencil, no eraser. Now I come up with a pencil with the eraser on the top so that it can use the dual purpose. So there is an inventive step. Inventive step means it is having a technical advance as compared to the prior one. Now industrial application. What is industrial application? If this pencil can be manufactured in large scale or in an industry, yes, then we can say this product is patentable. So for the patentable criteria, we have to check the three main thing. What is first one is the novelty, second one is the inventive step, and third is the industrial application. If three criteria is passed by any product or any process, then it is under the process of patentable criteria. Now come to section 3 and section 4 of the Indian Patent Act. See, every country have their own statute which bar something get not patentable in by keeping in view of the large perspective of the people. Suppose somebody is patented a drug and he is getting the patent. See, I already told you patent is a negative right, is an exclusive right. Exclusive right means it excludes others from using, selling, manufacturing or importing that particular product. Suppose let's say suppose I am an inventor and I am having a new drug. Let's say nichromycin. That particular drug is used for treatment of cancer, and I get the patent granted in India. So I got the monopoly right. What I will do, I will make the 10 tablet and I will say 80,000 for 10 tablet. So what you will do, if I will get the same, if I will get 80,000 by selling 10 tablet only, so those people who are not afford to take that medicine, they can't use that medicine. So this medicine is not useful our Indian perspective. So to stop that kind of thing, what the Indian government did, they enacted a law, they enacted an act, that is Indian Patent Act 1917. They inculcate some section there, just like section 3, section 4, and through that section will stop. We'll say, look, you are asking too much, and that is not patentable. See, we can't afford that kind of amount to our the people who are just below poverty line of the middle class people. So these are the section which stop this kind of people. Now come to product. What is product? Product means either it can be an apparatus, or it can be a device, or it can be a machine, and it can be a chemical product, or it can be a drug and food, or chemical composition, or a biological product. So these kind of product you can go for any patent. You can ask for a patent application, and you can go for patented of this kind of product. Now come to what is non-patentable. So this is most important one. So before knowing what is non-patentable, what is patentable, you must know what is non-patentable, so that you should not waste your time, your money, your work on those areas which are not patentable during your research. So what are not patentable? Anything which are frivolous in nature, or anything which is just contrary to the well-established nature. Suppose I am having a machine. I'm saying that without fuel it will go on, it will go on work on and on and on and on. This is against the nature. Somewhere and some point is going to stop at the end of the what you call decay of the fuel. So it is against the natural law. So these kind of things are not patentable. Suppose somebody is getting a product which is injurious to public health or plant or environment. Just we are still debating on the BT cotton. Still somebody is showing that it is what you call injurious to environment, some insect, some plant. Still you are debating. Still the scientific community are debating. So these kind of product is still not patentable. The scientific principle of abstract theory or new property of a known substance. So these kind of people are just a mixture of certain processes, method of agriculture, the plant and animal in whole, essential biological process, the mathematical or business method, the computer program per se or algorithm. Come on. Now come to this computer program per se algorithm. Recently, Delhi High Court in his verdict said that a computer program which is used for improvement of a device is patentable, but only a computer program itself is not patentable. If you are using that particular program to improve the efficiency of a device, then it is patentable. Recently, in 2019, the Delhi High Court has just given his verdict on this particular issue. Now come to patentability criteria. Yes, we have already discussed the patentability criteria. It must be an invention. It must involve the inventive step. It must be capable of industrial application, and it should not be under the purview of the section 3 and section 4 of the Indian Patent Act. Now come to filing system. This is most important. Now, who can file? Suppose I am working in a laboratory and I am under the university, then how I can go, where I can go, and in which way I can file. See, who can file the application for a patent for intellectual property? Either you alone can file or you jointly can file. Suppose in a laboratory, me and my colleague, we are working jointly on a particular problem. So if we got a product, so we both jointly we can file on behalf of our both name, we can file for the form for the patent application. So who can file? Any person claiming to be the true and the first inventor. Who are the true and first inventor? As I told you, suppose I am working in an lab, and me and my friend, we both are working on a laboratory on a particular area, then we are the true and first inventor. Now, by any person being assigned a person claiming to be true and first inventor. Now, suppose me and my friend working under a laboratory, and this laboratory come under an institution, let's say your university. So what we'll do, we will assign the invention to your university, so that instead of us, your university can file. So why? Because we the true and fast inventor, we assign our work to university because he has invested a lot of money. So he will file with the name of applicant, but in the inventor column he has to mention the true and fast inventor is Mr. Subrat Sahu and Mr. X. These people has worked on behalf of our university. And now the third person who can file, any legal representative of a disease person. Suppose somebody is working on a laboratory, by during the process of development of product, he just got died. So what we'll do, before getting died, he has entitled to someone, so that on behalf of that person he can file. So that legal representative can also file the patent application. Now come to category of application. This is most important. See, you people are working in a lab scale manner. Now suppose you are working from lab, you want to get the product from lab to land. For that you need to get a specific kind of scale up. From laboratory you just develop a prototype. From prototype to product you need a business incubation center. For most of the university nowadays having the business incubation center, so that prototype to product, your business incubation center can provide you, the same kind of things. Okay, so the who are the category of application? The natural person, the startup, the small entity, and the legal entity. Who are the natural person? As I already disclosed, I and we who are working in the laboratory are the natural person. Now come to startup. Suppose we are the natural person, we don't have that kind of expertise to develop our product to large scale or develop our prototype to a product in a large scale manner. For that, we need to go the business incubation center, because the business incubation center, they are having the people, the expertise who can develop your product into a large scale of product. So we can assign our own this what you call the patent to that particular startup, so that he can move forward or your patented product. Now come to small entity. See, small entity means any company or any enterprises which is having a turnover less than 10 crore as per the MSME Act 2006 are known as small entity. They can also file a patent. Beside these, those person who can file the patent, this comes from the large entity. Sorry, we have mentioned a legal entity. This is not a legal entity. This is a large entity. Beside the natural person, startup, and small entity, those person who is coming under this, they are the large entity. So the what is startup and this small entity as far as Indian Patent Act is concerned, we'll discuss one by one in the our next slide. Now come to yes, you know we are going to file the patent. Now the question is where you are going to file the patent. Suppose you people are working in a universities that is located in the Andhra Pradesh. So our Indian government divided the whole territory into 4 different jurisdictions. What are the jurisdictions? That territorial jurisdiction, the people who are working on a particular jurisdiction, they can file at that particular offices. Suppose you people are working on an Andhra Pradesh, an university under the Andhra Pradesh, then you people are eligible to file an application in Chennai office only, not other, because your jurisdiction is restricted to Chennai. Similarly, if somebody is working in Mumbai, somebody is working in Madhya Pradesh, then he or she has to file in Mumbai office. Suppose I am working in the IT Delhi here, then my jurisdiction is Delhi. If somebody working in Punjab, Rajasthan, then it is called the New Delhi. And rest of the India, they will file their patent or intellectual property right in the Kolkata. So these are the kind of jurisdiction where you can go and file your application. Now come to next section. This is a large structure of our Indian patent system. See, where I have already told you, we have the different intellectual property right with respect to patent, trademark, design, geographical indication, copyright, semiconductor. So these are the our different geographical location, and we are having different offices where you can go and file your office. That means you no need to go physically and go or file the file on the particular office. Nowadays, we are providing you an option of e-filing. Suppose you are sitting in Andhra Pradesh University, if you can want to file a patent on intellectual property right, then through e-filing you can choose your jurisdiction, the Chennai office, and through e-filing you can submit everything, and within a day your all filing procedure is ready, and you will get an acknowledgement that yes, we got your file and we are now proceeding with your file. So we are having different offices. What are the offices? We are having the patent offices, as I have already discussed. It is located in Kolkata, New Delhi, Chennai, Mumbai. Similarly, the trademark for trademark registry, you can we are having a new office just located in Ahmedabad beside the four metro cities. Now the for the designing, for designing you have to contact the Kolkata office. For geographical indication throughout the India, we need to contact the Chennai office. For copyright, we need to contact all the New Delhi office. Similarly, the semiconductor or any layout design registry, we are also asking for the New Delhi office. See, suppose some people of the university, they want to see patent is a legal, techno-legal document. So all the people are not expertise to draft that particular document. So that we are providing the what do you call? We are providing the training in Nagpur. We have a specific institution known as Rajiv Gandhi National Institute of Intellectual Property and Management, which is situated in Nagpur, where we basically provide training for those professors, those PhD scholars, those scholars who want to pursue their career or who want to draft their patent for their own university or somebody else. They can join for a 4-month or 6-month course available with very limited amount of fee through government in RG and IPM Nagpur. So these are the all basic location which we are providing as a Ministry of Commerce and Industry under control of General of Patent, Design and Trademark. Now, see, suppose somebody working in an university and some another person who take away his idea and file before him. Then who will go to solve that problem? For that one, what we did, we just inbuilt an appellate board that is basically situated in Chennai, which basically told which basically stop these kind of things, which is very nuisance, very obstructive in nature, to stop our technology should carry out somebody else our technology. For that, we are already set out an appellate board. We can appeal your problem. Now, for any promotion of the intellectual property, for awareness, we are also an office known as the CPAM, Center for Intellectual Property Promotion and Management, that is situated in New Delhi. So basically, these are all the offices which are cordially, we all are working as a team for the protection of intellectual property right throughout the country within its jurisdiction. Now, come to physical filing. Suppose there is two method of filing. Initially, before 2007, we are asking for the physical filing. After 2007, we are both asking them, you can go for physical